A quality business operating agreement in Oklahoma County should do more than identify the owners of an LLC. It should explain how the company will be owned, managed, funded, operated, taxed, and protected in the event of disagreements or major life events. A strong operating agreement acts like the rulebook for the business. It helps prevent confusion, reduces the risk of disputes, and gives the owners a plan before problems arise. Clear identification of the owners. A quality operating agreement should clearly identify each member of the LLC and state each person's ownership percentage. It should also explain how that ownership was earned. One owner may contribute cash. Another may contribute equipment, real estate, inventory, intellectual property, customer relationships, or services. These details should not be left to memory. If the business becomes successful, or if the relationship between the owners breaks down, unclear ownership terms can become the center of a serious dispute. A good agreement should state who owns what and why. Capital contributions. The agreement should describe each member's initial capital contribution. It should also explain whether members are required to contribute more money later if the business needs additional funding. This is important because businesses often need more money after formation. The company may need to buy equipment, lease space, hire employees, pay taxes, purchase inventory, cover payroll, or survive a slow season. The operating agreement should state whether additional contributions are mandatory, voluntary, or subject to member approval. If one member contributes more money later and another member does not, the agreement should explain whether ownership percentages change, whether the contribution is treated as a loan, or whether another consequence applies. Management structure. A good operating agreement should state whether the LLC is member-managed or manager-managed. In a member-managed company, the owners participate directly in running the business. In a manager-managed company, one or more managers are given authority to operate the company. Oklahoma law allows an LLC to be managed by or under the authority of one or more managers unless the Articles of Organization, Operating Agreement, or LLC Act provide otherwise. For that reason, the agreement should clearly explain who has authority to make decisions, sign contracts, hire employees, borrow money, open bank accounts, lease property, and bind the company. Voting rights and major decisions. The operating agreement should explain how votes are counted and which decisions require approval. Some decisions may be made by a majority vote. Others may require unanimous consent or approval by members holding a certain percentage of ownership. Major decisions should receive special attention. These may include selling company assets, admitting a new member, borrowing money, changing tax treatment, buying real estate, entering long-term contracts, hiring key employees, selling the business, merging with another company, or dissolving the LLC. Without clear voting rules, one owner may believe they have authority to act while another believes approval was required. That type of misunderstanding can damage both the business and the owner's relationship. Authority to sign contracts. A quality operating agreement should specify who may sign contracts on behalf of the company. This includes leases, vendor agreements, loans, purchase contracts, employment agreements, settlement agreements, and customer contracts. This provision is especially important when the business has more than one owner. If every member has authority to bind the company, the business may be exposed to obligations that other owners did not approve. If only certain people have authority, the agreement should say so clearly. Profit, loss, and distribution rules. The agreement should explain how profits and losses are allocated among the members. It should also explain when money will be distributed to owners. Owners often assume profits will be distributed based on ownership percentage. That may be true, but not always. Some businesses use a different arrangement because one owner works full-time, one owner contributed more capital, or the members agreed to reinvest profits for growth. The agreement should also explain whether distributions are mandatory or discretionary. A business may need to keep money for taxes, payroll, inventory, insurance, loan payments, equipment, or expansion. Clear rules help avoid conflict when one owner wants distributions and another wants to keep money in the business. Member duties and work expectations. Many LLC disputes happen because the owners never agreed on work expectations. One owner may believe that all members will work full-time. Another may believe their contribution was money only. One owner may handle sales while another handles operations. If those roles are not written down, resentment can build. A quality operating agreement should explain each member's duties, authority, compensation, time expectations, and limits. It should also address whether members may work for competitors, start similar businesses, take company opportunities, use company property, or solicit company customers. Compensation for working owners. Ownership distributions and wages are different concepts. An owner may receive a distribution because they own part of the company. A working owner may also receive compensation for services performed for the business. The operating agreement should explain whether working members are paid salaries, guaranteed payments, draws, bonuses, commissions, or no separate compensation. This prevents disputes when one owner works in the business every day and another owner is passive. Buyout rights. A strong operating agreement should explain what happens if an owner wants to leave. Without buyout rules, the business may be stuck with an inactive, hostile, disabled, divorced, bankrupt, or deceased owner's interest. Buyout provisions should explain when a buyout is allowed or required, who may purchase the interest, how the ownership interest is valued, how payment will be made, whether discounts apply, and whether the departing owner remains subject to confidentiality or non-solicitation obligations. Death, disability, divorce, or bankruptcy of a member. A quality operating agreement should plan for difficult events before they happen. If a member dies, becomes disabled, gets divorced, files bankruptcy, or has a creditor trying to reach their interest, the business needs clear rules. Without planning, a spouse, heir, creditor, bankruptcy trustee, or former family member may become involved in the company. The agreement can restrict transfers, limit management rights, create purchase options, and protect the company from being disrupted by events outside the business. Transfer restrictions. The agreement should state whether a member can sell, assign, pledge, or transfer their ownership interest. Most small businesses do not want an owner to sell part of the company to a stranger, competitor, creditor, or family member without approval. Transfer restrictions should explain what happens if a member wants to sell, whether the company or other members have a right of first refusal, and whether the buyer receives only economic rights or full membership rights. This is especially important for family businesses and closely held companies. Deadlock and dispute resolution. If a business has two equal owners, deadlock provisions are critical. A 50-50 LLC can become paralyzed if the owners disagree and neither has final decision-making authority. A quality operating agreement should explain how deadlocks are handled. This may include required meetings, mediation, tiebreaker procedures, buy-sell rights, rotating authority, or court remedies when necessary. The goal is to keep the company from collapsing because the owners cannot agree. Tax treatment and accounting. The operating agreement should coordinate with the company's tax treatment. An LLC may be taxed as a disregarded entity, partnership, S corporation, or C corporation depending on the number of owners and tax elections made. The agreement should address accounting methods, fiscal year, tax returns, tax distributions, capital accounts, records, reimbursements, and who works with the CPA. Legal drafting and tax planning should match. If the agreement says one thing but the tax treatment requires another, problems can develop. Books, records, and bank accounts. A quality operating agreement should require the company to maintain proper books, records, and separate bank accounts. The LLC should not mix personal and business money. It should document capital contributions, distributions, loans, major decisions, contracts, tax filings, and ownership changes. Good records help preserve the separation between the owners and the company. They also make it easier to resolve disputes, prepare taxes, obtain loans, sell the business, or respond to legal claims. Confidentiality and company information. Many businesses rely on confidential information. This may include customer lists, pricing, vendor information, marketing plans, trade secrets, financial records, passwords, software access, employee information, and business strategies. The operating agreement should protect that information. It should explain what information belongs to the company, who may access it, how it may be used, and what happens when a member leaves. Limits on personal use of company property. A strong agreement should address personal use of company money, vehicles, equipment, credit cards, employees, and accounts. Many business disputes begin when one owner believes another owner is using company property for personal benefit. The agreement should set clear rules for reimbursements, expense approval, credit card use, company vehicles, personal charges, and documentation. Clear rules make it easier to prevent misuse and easier to correct problems if they occur. Admission of new members. The operating agreement should explain how new members may be admitted. Adding a new owner can affect control, profits, taxes, voting, management, and company culture. The agreement should state who must approve a new member, what documents must be signed, what contribution is required, and whether the new member receives voting rights, profit rights, or both. Bringing in a new owner should never be handled casually. Dissolution and winding up. A quality operating agreement should explain when the company may be dissolved and how its affairs will be wound up. This may occur if the owners agree to close, the business is sold, a major purpose becomes impossible, or a triggering event occurs. The agreement should explain how debts are paid, assets are sold, records are handled, remaining money is distributed, and final tax filings are completed. Ending a business is easier when the rules were written before conflict began. Talk to an Oklahoma County business attorney.